Morning everyone and welcome. We're pleased to invite you to this key update webinar on the Employment Rights Act 2025. Before we begin, just a little housekeeping. Your cameras and microphones are set to remain switched off throughout the session. We're recording today's webinar. We may use that recording in future communications. We'll be taking questions at the end. As I said, you can raise those using the Q&A button on your Microsoft Teams. If you submit a question, just so you're aware, both your name and the question will be visible to all other attendees. Alternatively, if you prefer to ask a question offline, our contact details will be provided towards the end of the slides. So to begin, we'd just like to introduce ourselves. Joining us on the webinar today is Phil Richardson, Head of Employment. Phil's going to be talking us through the changes which are coming in 2027, in particular enhanced rights around unfair dismissal and changes to the compensation limits in the tribunal. Myself, I'm a partner of the team. I'm going to be discussing some changes which have recently come in February regarding industrial action, but in particular changes around parental and paternity leave and sick pay, and some other changes which are coming into effect in April. And Stephen Woodhouse, Senior Associate, will be talking us through changes which are coming in October around sexual harassment and enhanced duties on you guys to prevent sexual harassment, together with further changes to trade union rules and changes to tribunal time limits. Right. So I won't spend too much time on these. I'm not sure how many of you recognise a trade union, so I've not focused too much on this. But I've just highlighted some changes of particular significance. So these are changes which have already come into effect on the 18th of February this year. First up, dismissal for taking part in industrial action is automatically unfair. It's always been automatically unfair. However, the Employment Rights Act 25 removes the requirement for that dismissal to take place during the first 12 weeks of industrial action, also known as the relevant period. So in other words, employees will be protected from unfair dismissal during any lawful industrial action that occurs within the lifetime of the mandate of the ballot for that industrial action. Secondly, the time needed to give notice of industrial action has been reduced to 10 days. Formerly that was 14 days. Thirdly, industrial action mandates for ballots opening on or after the 18th of February. These are extended to 12 months. Previously, that was 6 months. And finally, the support threshold rule has been removed. So this rule required at least 40% of those eligible to vote to support action. It applied to important public services. Public and private sector ballots now follow the same requirement. They only need more votes in favour of industrial action than against. So what does it mean for you guys? Just some practical considerations. Tighter contingency planning. So the shorter 10-day notice period means employers have less time to prepare for disruption. Contingency plans need to be reviewed to ensure they're actionable within this shorter window. There's longer term risks. So with the 12-month mandates, unions can call action months after a ballot, requiring you guys to maintain consistent risk assessments rather than treating strike threats sort of as short-term issues. And handling dismissals. So the removal of the 12-week limit for protection against dismissal means that dismissing anyone for taking part in industrial action is extremely high risk. You guys must have robust, non-strike related reasons, of course, for any dismissal, or alternatively wait until the dispute is resolved. Moving on to parental leave and paternity leave. So with effect from the 6th of April, the following important changes will come into effect. Currently, someone must have worked, as you're perhaps all aware, for their employer for 26 weeks. However, from the 6th of April, paternity leave will become a day one right. That allows someone to give notice of leave from the first day of their employment. Ordinary parental leave or unpaid parental leave, that too will become a day one right. Currently, someone must have worked for their employer for 1 year to be eligible, so that's been removed. Under the current rules, paternity leave and shared parental leave were mutually exclusive, but of course this restriction will be removed in April 26, and from April 26, eligible fathers and partners will be able to take paternity leave even if they've already taken shared parental leave. It's important to note, however, that the 26-week qualifying period for statutory paternity pay, as opposed to leave, that remains unchanged. So they still need to have worked there for 26 weeks to receive that paternity pay. Eligible fathers and partners will be able to take up to 52 weeks of unpaid bereaved partners' paternity leave. That's if the mother or primary adopter dies. They must take this leave within 52 weeks of the child's birth. That includes surrogacy, adoption placement, or entry to Great Britain for overseas adoptions. Again, this is a day one right with no minimum qualifying period and is specifically intended to support surviving partners with caring responsibilities during a period of significant trauma. Just so you're aware, those rights in relation to bereaved partners' paternity, that's contained under separate legislation, Regulations 2026, but just an important change that you need to be aware of. So what does that mean for you guys? Well, it's important, of course, to update your policies and staff handbooks. Review and update your paternity leave policy, parental leave policy, shared parental leave policy, and take a look at your bereavement and compassionate leave policies. Make sure that they reflect the new day one rights and the removal of those restrictions. These need to be updated before April 2026. Don't forget to check and update any intranet pages, onboarding materials, and employee guides that you may have issued. Review, of course, your recruitment and onboarding materials. Now, because these entitlements start from day one, candidates and new starters may well ask about them. So make sure that your recruitment teams, managers, any onboarding staff understand these new eligibility rules, how notice for paternity leave can now be given from day one, and of course your internal processes for managing those requests. You need to prepare managers and HR teams. Line managers will often be the first point of contact, so they need clear guidance. Consider running short training sessions, updating frequently asked questions, and scenario-based guidance can be helpful, especially for requests made early in employment. Review your resourcing and cover arrangements. Consider building in flexibility to account, of course, for the possibility of more short notice leave requests. Of course, payroll and HR systems need to be ready, and check your HR and payroll systems. Now recognise that day one eligibility. They flag any of those entitlements correctly, and ideally you're able to generate compliant letters and documentation. Next up is sick pay. So under the existing framework, statutory sick pay operates, of course, with numerous qualifying conditions. Employees must earn at least £125 per week, which is the lower earnings limit, to qualify for SSP, and payment only begins, it's an important note, from the 4th qualifying day of sickness absence, which means the first 3 days of absence are unpaid, unless, of course, you guys operate a more generous sickness policy. The removal of waiting days, the long-standing requirement, of course, for employees was to wait 3 days before they start to receive SSP. That will be abolished. So from April 2026, eligible employees will receive SSP from their first qualifying day of absence. The reason for this is because the government believes that this change will support phased returns to work. Employees will be entitled to SSP for each day not worked due to sickness. And so, for example, a full-time employee returning to work on a 3-day per week phased return following a lengthy absence will receive SSP for the remaining 2 days. So it's to encourage that return to work. There is the abolition or removal of the lower earnings limit. So the requirement for staff to earn at or above £125 per week will be removed entirely, extending SSP eligibility to all employees regardless of their earnings. This change will bring additional workers, including part-time staff, those on 0 hours contract and lower paid employees within the scope of this statutory sick pay protection. What's also important to note is that there is a new payment calculation. So for lower earners, SSP will be calculated at 80% of the normal weekly earnings, or the flat weekly rate of £123.25. That's from April 2026, whichever is lower. The 80% calculation is intended to strike a balance really between providing financial security for the employee while limiting additional costs for you guys as employers. So what does that mean for you, and what can you do to prepare for this? Well, the government estimates that removing this waiting period and the lower earnings limit will cost employers approximately £450 million annually, equating to roughly £15 per employee. The reforms are likely to have the greatest impact on employers with large, low-paid workforces that don't currently offer contractual sick pay, and those experiencing higher rates of short-term sickness absence. So what can you do to prepare for the changes? Well, you should consider the following: review and of course update sickness absence policies to remove reference to those waiting days and the lower earning limit. Any equivalent waiting period in company sick pay schemes should also be reviewed. Ensure payroll systems are up to date to accommodate the new 80% calculation for those lower earners, and again the removal of that 3-day waiting period. Make sure that you liaise with payroll providers to confirm when system updates will be available. Carry out an absence audit covering the past 12 to 24 months to model, if you can, the financial impact of those changes, and you may need to adjust your budgets accordingly. Train managers on dealing with sickness absence effectively, maintaining accurate absence records, and where possible identifying patterns that may warrant further investigation. Strengthen those return to work interviews and absent management procedures. Also consider appropriate triggers for formal discussions around absence. So collective redundancy protection awards. So again, this comes in on the 6th of April 2026. Now the present position where an employer is proposing to dismiss as redundant 20 or more employees at one establishment within a period of 90 days or less, you must consult with representatives of those affected employees. So the collective consultancy rules kick in. That consultation needs to be in good time, as it always has been, and where you're proposing to dismiss 100 or more employees at one establishment, again within a 90-day period, that consultation needs to take place at least 45 days before those first dismissals take place. Otherwise, at least 30 days. So the Act retains the existing at one establishment trigger. So dismissing 20 or more employees at one establishment, the new legislation doesn't change that. But what it does do is add a second alternative trigger, and that's to cover cases where employees are being made redundant at more than one establishment. In the event of non-compliance, currently a protective award may be awarded of up to 90 days. I say up to 90 days, gross pay per affected employee. A failure to provide, some of you may be aware of the HR1 form that's submitted when you're considering making those redundancies. Failure to provide that notification risks a criminal offence. More importantly, the new legislation doubles that of protective award. So it's no longer 90 days for a failure to inform and consult, or the equivalent pay of 90 days. That's doubled to 180 days pay. Government guidance, the government is going to introduce regulations setting out this second trigger threshold number before those changes can come into effect. But some practical considerations for you guys before that does come in. Once the new threshold is in force, it will particularly affect employers which operate across more than one location. So those employers should implement centralised tracking of redundancy proposals to monitor whether this new threshold is met. Audit the redundancy procedures, so review your collective consultation approach to ensure, of course, compliance, particularly when proposing to make 20 or more members of staff redundant within those 90 days. You may want to consider extending that consultation period. So you may build in longer consultation periods beyond that statutory minimum, just to avoid any allegations of rushing the process or failing to genuinely consult, particularly because the stakes are a lot higher now with those 180-day payments for awards, which is a lot for each of those members of staff. Prioritise genuine consultation, so focus on genuinely consulting on ways to avoid, reduce or mitigate the consequence of redundancy, rather than treating this as a tick box or procedural exercise. Ensure meticulous documentation of the consultation process and make sure your managers are trained on the increased risks and specific legal requirements. Lastly, you need to prepare for increased scrutiny. The government intends to produce a code of practice on collective redundancy obligations, and there will be a new Fair Work agency coming into effect, in which case you need to expect closer scrutiny of those redundancy decisions and those consultation processes. Finally, from me, just a note on whistleblowing protection. You perhaps will be familiar with the concept of whistleblowing. Someone makes a protected disclosure, and if they are put to a detriment or dismissed, that will be a breach of the legislation. Currently, those protected disclosures, employees need to show that their concern fell into a category of wrongdoing, essentially, such as a criminal offence or a danger to health and safety, in order for them to be protected. And typically, those were seen as relating to fraud or dangerous practices. From the 6th of April, however, disclosures about sexual harassment will also be expressly recognised as a form of whistleblowing. And so employees making allegations that sexual harassment has occurred, is occurring or is likely to occur will be protected from detriment, which is any adverse treatment because of the raising of that concern, and unfair dismissal, which can also be treated as automatically unfair, so they don't need to have worked with you for at least 2 years. If they're dismissed for raising that concern about sexual harassment, they will be deemed to have automatically been dismissed. The logic of that is is the protection. It will prevent employees from feeling as though they cannot speak up due to fear of career damage, being disbelieved, or being labelled as a troublemaker. So, practical steps for you guys. First one, of course, review and update your whistleblowing policy to explicitly refer to sexual harassment as an example of reportable wrongdoing. You may already have separate sexual harassment policies. You may want to consider aligning sexual harassment, grievance and whistleblowing procedures to make the way that they will be triage clear. Train managers and HR to recognise when a concern relating to sexual harassment may amount to a protected disclosure and how they should respond in a way that avoids allegations of detriment or victimisation. You may need to review any non-disclosure agreements and settlement templates. That will be important. And finally, strengthen the culture and reporting channels so that employees feel empowered and able to speak up early. So that's everything from me. I hope you found that useful, and I'll pass you over to Phil Richardson.
It's actually Steve, isn't it?
Yeah, good morning, everyone. Yes, so my name's Stephen Woodhouse, as Adam said at the start, senior solicitor in the employment team. Thanks for everyone for joining up. We've got really good turnout this morning. That's really positive. Adam's talked about the changes that either have come in February, for example, or are coming into force imminently. So they're locked in. But as we said at the start, myself and Phil will be looking forward to October and Phil into 2027. And because these are 7 months away at the earliest, there is an element of forecasting to these things. There are ongoing government consultations. There's definitely still some details that are going to be ironed out. But we fully expect all these changes are going to come in, and we need to arm ourselves now with the knowledge of them and consider how we can best prepare. Just a reminder for everyone as well, we've got the Q&A box open for questions. So as and when you feel ready, pop a question in the box and then we'll try and deal with that at the end. But the first change I'm going to discuss is in October 2026, and it's strengthening the law around sexual harassment prevention. But to understand that, we need to understand where we stand today. And the present position was introduced fairly recently as well. I think it was October 2024, where the government introduced a formal duty, a statutory duty for employers to take reasonable steps to prevent sexual harassment. And you may recall the publicity around this at the time, and I think it encouraged quite a lot of employees to come forward to raise concerns and also, as a knock-on effect of that, bring tribunal claims. And that's borne out in the statistics from the time period as well. So in the year prior to the introduction of that new legislation, there were 457 claims of this type, and it went up to 1,375 in the year afterwards. So it almost trebled. So a massive, significant increase, and I think the publicity has a lot to do that. But as noted on the slide there, the duty now changes so that from October 2026, we've got to take all reasonable steps as employers to prevent sexual harassment. And the introduction of that word all, it's naturally putting a greater burden on us, and it does raise the standard to a much higher bar. But I'm sure you're all sat there wondering, well, what does that mean? What are all reasonable steps? Now, rather unhelpful, and it perhaps won't be the first time I mention this today, the government have failed at this stage to define exactly what that means in clear terms. So as employers and advisors, we've got to apply our minds to the issue and consider what constitutes all reasonable steps. And as an overview, and I'm going to come on to some more detail in a moment, but reasonableness always takes into account issues of the size of the business, the resources of the business, the type of environment that your business operates within. What are the risks on a day-to-day basis that you're likely to come across? I do think there needs to be further clarification and support from the government and the tribunals to clarify the specific practical steps we can take. But I'm going to come on in a slide in a moment to discuss my thoughts on that and where you guys can get things in place now to best protect yourself from this new legislation. Before I do that, I just want to touch upon the issue of third-party harassment liability. And again, we need to go back to look at the brief history of it. In 2013, the law around third-party harassment liability was changed, and therefore we were no longer liable as employers for a third party committing an act of harassment against our employees or our workers. That's changed now, or it's changing as of October 2026. So if you have a client, a customer, a supplier, a contractor who harasses one of your employees, you can be held liable for that. Okay, so it's another burden that we've got to be aware of. We can be accountable if we haven't taken all reasonable steps to prevent it. So again, the two things go hand in hand. The one distinction I would make with the third-party harassment is that it applies to sexual harassment, certainly, but it actually applies across the board to all forms of harassment, all forms of protected characteristics. So it applies to harassment on the grounds of disability, age, race. So we've got to be mindful of it in the wider sense, but I'm just going to think about on the next slide now the practical steps that you can take to prepare and demonstrate that you're taking all those reasonable steps that are possible. So the first thing I'd say is you need a clear, regularly updated policy addressing harassment. You need to outline what you class as unacceptable conduct. You need to make clear the reporting mechanisms for employees to come forward if they have an issue. You need to outline what investigation processes you have in place and appeals and various different stages to your investigation, and also what support you can offer for the victims and the people who are alleging that they've been subjected to harassment. Do you have an employment support line, for example, that they can access? So think about ways in which you can make clear the policies and procedures on that. We need to engage with staff. So we need to be having regular one-to-ones. We need to be having surveys, exit interviews, open door policies that can identify the issues and evaluate the effectiveness of the measures that we're putting in place. We need to be conducting risk assessments. We need to be identifying and mitigating the risks of sexual harassment or any form of harassment for that matter. Where is it likely most likely to come up, and how can we best mitigate those risks? And that again might be about third-party interactions and how we manage that. Another suggestion is that we consider appointing a designated person, a lead, to oversee preventative actions. We need to encourage reporting as well, and we need to put mechanisms in place that allow us to do that. So there might be multiple channels of reporting lines. So for example, I know one of my clients who's got a HR team. They've got managers and directors that people can go to, but they also have an anonymous system whereby an individual can freely and confidentially raise a concern without fear of reprisal, because we also have a duty to protect individuals who come forward from being victimized, from being treated badly or bullied even because they've spoken out. So we need those mechanisms in place, and that confidential line could be the way to go. We've also got to be regularly updating staff training. We need to be giving mandatory training to employees on the issue of workplace behaviour. What are the standards that we expect as an organisation? And we need to reinforce those across the business. What complaints procedures do we have in place? And then you also need to consider, is there additional training that you can have for managers on handling complaints and supporting victims? And then we need, when we are having an investigation, when we are presented with a complaint by an individual, we've got to investigate that promptly. We need to resolve it appropriately, and we need to prevent them from being victimised, as I mentioned earlier. And underpinning all of that, we need to be regularly reviewing this. We can't just have a policy in place and then leave it to gather dust. We need to be regularly reviewing them, looking at our risk assessments, looking at the complaints data. How many complaints have we had in of harassment, and what trends are coming from those? And doing that's going to allow you to assess the effectiveness of the measures you've got, but also then take action to make the necessary improvements. The final thing I'd make, point I'd make, and a key message I want to convey, is that you can only do what is reasonable. So I've given a whole host of things that you guys can put in place, but they're not going to be either possible or feasible for each and every one of you. So reasonableness is going to play a massive part in this. You might not have the resources. You might have fewer than 10 employees. You might not have the employees. You might not have the finances to implement each and every one of these steps that I've suggested, but try where you can to at least consider them. And if you can't implement them, be ready to justify that, for example, on the grounds of cost, on the grounds of resources. So that deals with the changes to the law around harassment that's coming in October 2026. I'm going to briefly touch upon changes to the law around tipping. Now, obviously, this is going to apply to those in the hospitality industry, and there are significant changes coming which are listed on the slide there. We're going to have a requirement on employers to consult with employee representatives or directly with workers if there's no representatives that exist before they produce or update a tips policy. You've got to review a tips policy at least once every 3 years and consult with the employees during that review process. And there's also a duty to make an anonymised summary of the views expressed during that consultation process available to all workers so that they can understand what's been discussed. and the government are going to produce an updated statutory code of practice on this, so they can outline how the fair and transparent distributions of tips and service charges will work, and that's going to be produced before the new requirements take effect. So that just deals briefly on the laws around tipping that will come in October. A further change, and Adam's touched upon some of the trade union stuff that's already coming in or is coming in April. There are further changes coming down the line as well, and they will come in October. And I've listed those on the slide there. But effectively, the first one is that we're required as employers to provide workers with a written statement of the employee's right to join a trade union. That would be expected, we think, to be provided alongside their Section 1 statement of employment particulars, as we all know it, a contract of employment usually. There are going to be regulations on that. The government's going to specify exactly what it should look like, the form, the delivery method of that statement. So certainly one to keep an eye on as we progress through 2026. But that's certainly something that's going to come in, and we have to inform them of their right to do so. As an extension of that, there is going to be the opportunity for qualifying trade unions to gain the right of access to workplaces to deal with things like recruitment and organisational issues. However, the government have been very clear, and the legislation is clear, that this excludes them coming in to organise industrial action strikes. Again, we're expecting a code of practice on that. And I think the government's communication on that point is important. We need to be very clear. I know it's something that's concerned some people I've spoken to in recent weeks. My view is it's not going to allow unions to walk in and overnight unionise your employees by any means. There's got to be very clear access agreements that are agreed with employers, that are ratified by the appropriate authorities before that can happen. And again, the regulations that are going to come out on that and the guidance on that, I think, is really important to understand what's going to happen in practice. I think for me, the mood music I'm getting is that the trade unions are much more likely to focus their resources on larger, well-known employees in the first instance. Therefore, I think it's unlikely in the short term to impact on small and medium businesses, but it's certainly one to have on your radar. Adam touched on the issue of dismissal for taking part in industrial action, and the law in October 2026 is going to be expanded to protect them from detriment, and detriment is just effectively being treated poorly because they've taken part in industrial action. And in practice, detriment is things like subjecting them to warnings, demotions, pay reductions, or any further action of that kind that is detrimental to them. So it's important that you are, and it's important we're aware actually that it doesn't prevent them, it doesn't give them a cloak of invincibility that you cannot take action against any individual if they've taken part in trade union activity in the recent weeks. But what it does mean is that you can't subject the employees to detriment, negative treatment, specifically because they've taken part in that industrial action. And the final point on the slide there is that they've got to be given, trade union representatives that is, they have to be given the right to time to do to undertake their activities, and that time should be paid as well. And we need to give them the appropriate facilities on that. As ever with these things, on the trade union side, there's going to be further government guidance and code of practice to come out as we approach October before it kicks in. So one to look out for further. And I mentioned there on the slide about employment tribunal time limit. So just to recap, at the moment, although there are some exceptions to the rule and extensions that can be gained for ACAS, the simple rule is that employees have 3 months within which to lodge a claim. So if that 3-month window passes effectively and they've not taken any legal action of any form, then they will be prevented from bringing that claim. You know that once that time passes, you're clear, and that will not result in a claim for unfair dismissal or discrimination. What the legislation in October 2026 will do is extend that period now and it will double to 6 months, except for claims of breach of contract. So obviously that gives us cause for concern in a number of ways, really. The first is that it gives us more uncertainty. We don't have that clarification from an early point of view that once we know that period is past 3 months, there is no likelihood of a claim coming back. My concern is the tribunal system at the moment, for those of you who are lucky enough to be involved in it, is really creaking at the seams. So at the moment, it's taken around 18 months to 2 years for any claim that's submitted against us to reach a trial. And that is not desirable for anyone. And extending the scope of claims from 3 months to 6 months, and Phil will come on in a moment to discuss other extension of rights, which I think will have a very significant impact on the potential of claims. If we're waiting 2 years now for a claim to reach trial, it can only go one way. It can only be extended for my money into the future, which means it could be something like 3 years from the date of the incident before we get a resolution to the claim, which is not desirable for anybody, employee or employer. And this is something I said on the Employment Tribunal User Group Forum. It's something that we're making our concerns known to the judiciary at the moment, because the system is already struggling, and we can only see that worsening as time goes on. I think another point I'd say is that because the claim process is going to lengthen, that also means then that it might impact on your witnesses in two respects. First is that naturally, like anything, when time passes, memories fade. So if somebody is trying to recall their reasoning for dismissing a particular individual from 3 years earlier, it's going to be much more difficult for them to do so. So we're going to have a lot less clarity, really, and I think more problems in terms of giving evidence and giving a true account of events for something that's happened many years ago. My other concern about witnesses is that if it takes 2 to 3 years for it to reach trial, the individual manager who you employed, who perhaps dismissed the employee who's then brought a claim against you, they might have moved on. They may be in a new job and are no longer willing to support you. And a practical step I'd just leave you with on that is to try and safeguard against that by getting an agreement from those departing employees who you may need as a witness to say, look, in the event that person X decides to bring a claim against us, can you agree to support us and attend tribunal if a claim is submitted? Or if a claim is there, we definitely need to then line them up to be ready to help us in 2 years' time when the matter reaches trial. So that's certainly something which I think will expand the claims. And as I say on the slide there, I do have serious concerns about the tribunal's capacity to deal with that all. But that's October 2026, and we'll be around, of course, to advise you on things as they develop. There's more regulations coming out. There's more information coming from the government. There's more codes of practice. So as and when those come out, keep an ear to the ground. Make sure you're aware of these changes coming in and how they're going to impact on your business. But I'll hand you over now to Phil, who's going to discuss the changes that are coming in 2027. Thank you.
Well, thanks for that, Stephen. As Stephen's just said, I'm going to focus in my section of the webinar about the changes that are going to come into place next year. Now, I would caveat all this by saying that a number of the changes, there's still dates to be assigned as to when they're going to be coming into place. And also the sort of meat on the bones, as it were, is yet to be announced on many of the changes as we're awaiting regulations surrounding the changes. But I thought it would be useful for me to give an overview of those changes as well. But I'm going to start off with the first, and I'd say the major change in legislation that's coming into place next year. And that's the right to claim unfair dismissal. Now, as employers, you all probably aware at this moment in time that in order for an employee to bring a claim at an employment tribunal for unfair dismissal, they must have served 2 years service. Now, in a practical sense, that's given you a degree of flexibility in that you may have staff who behave themselves during the probationary period, and thereafter the performance dips and you start to notice concerns. That flexibility at this moment in time allows you during that period from 6 months to 2 years to consider taking steps to discipline and looking at dismissal action where conduct and capability slips significantly, and allows you to dismiss relatively easy, provided it's for a non-discriminatory reason, because of course discrimination claims can still be brought from day one, but it has allowed you that degree of flexibility. Now, as of 1st of January 2027, that flexibility effectively goes because it opens up the right to bring a claim for all employees who have served continuous employment of 6 months or more, and they will be eligible to raise a claim for unfair dismissal. And this will have retrospective effect, so those employees commencing roles from the 1st of July will automatically trigger that eligibility from the 1st of January next year. So what does that mean for you as employers? Well, first of all, naturally, it will give rights to many more of your employees to bring claims for unfair dismissal. So really, the key focus you should take away is that there is a need to strengthen your contractual terms and policies and procedures, particularly around probationary periods. Now, you probably all have contracts in place which have a probationary period clause, and that's usually of up to 6 months. That's usually the sort of standard, as it were. What we're advising is you should no longer rely upon that 6 month period. The reason being is that it's easy to lapse and forget, you know, as passage of time goes, that an employee's been with you for 6 months, and it can easily sort of take over where that person served 6 months and you've not given a thought to in a proactive sense as to their capability. So what are the alternatives? What we're suggesting is that you implement a standard review at the 3-month stage, so that if there remain concerns about capability or you're not quite sure about whether to pass them in probation, it gives you a degree of flexibility by way of a 2-month period, so that it's a 5-month maximum to assess performance in that period. So by the time you get to 5 months, you should then be in a position where you can form a reasonably informed view as to whether they're capable or not to keep them on. And that, of course, then prevents you from going over the 6-month period, meaning then you would have to follow quite an exhaustive process to avoid an unfair dismissal finding. So what we're suggesting is that in addition to reviewing your contracts and obviously changing the probationary period, you also have a standalone probationary policy, and that will set down regular reviews for between your managers and those members of staff, and indicate touching points as to when you will review performance and ensure they're sort of reaching the milestones that they should be reaching to get to a point where you can consider whether they should pass the probationary period or not. So certainly having a standalone probationary policy is something we're going to be recommending to our clients certainly over the coming weeks and months. The second change are changes to compensation limits in tribunals. So as well as opening up, I guess, extending the goalposts for people to be able to bring claims for unfair dismissal, when they get to tribunal, if they're successful, then the cap on compensatory awards is going to go as from next January. You may be currently aware that tribunal compensation for unfair dismissal is capped at either the lower of 52 weeks gross pay or this figure here of £118,223. So essentially, if somebody earns £60,000 a year, the maximum they can receive is £60,000. If they earn £150,000, they will receive that cap there of £118,223. However, as of January, that will go, which obviously means that there is no ceiling on unfair dismissal compensation moving forward from January next year. So what do you need to consider, therefore, with that in mind? Well, the first thing is to be conscious when you're dealing with any internal grievances, any disciplinary matters, that potentially, if they do escalate, obviously that exposes your company to risk. So do consider whether matters can be resolved at an early stage through your grievance process, whether informally or formally, and through the appeals process, because if it can, obviously it avoids that exposure. Sometimes it's not possible to resolve grievances internally, and you may stand by your decisions in terms of a disciplinary process. But obviously be conscious of the fact that before an employee brings a claim before an employment tribunal, they have to go through a process of compulsory conciliation through ACAS. So if you're not able to resolve it internally, you've got sort of a fallback position where through ACAS where you can consider if it can be settled at that time. Now, of course, it depends on what the claimant's expectations are at that point and whether they're on a different page in terms of what they perceive to be reasonable. But it does give you an opportunity to sensibly sit down and consider whether you can try and resolve the complaint at that stage, bearing in mind the potential exposure that the increase in compensation limits will have. Because as it says here, tribunal claims with no certainty on caps in compensation will result in increases and exposure as far as you're concerned. The next change that's going to be coming into place as of 1st of January next year is this concept of firing and rehiring staff. You won't any longer be able to dismiss staff and then rehire on less favourable terms. There's been notable examples in the press over the last few years, particularly of larger organisations who really should know better, of essentially basically compelling staff to accept contracts with less favourable terms. And these restricted variations, as they'll be known, include reductions in pay, pension and benefits, change in hours or shift patterns, and changes to annual leave entitlement. The automatic unfair dismissal won't be triggered by minor changes, but anything substantial that affects an employee's main terms and conditions, and as I say, those restricted variations are examples there that will become automatically unfair. So in a practical sense, what can you do if you're considering changing terms? Well, it will become more difficult to sort of enforce those changes on employees, and the government have made clear that it's only in a situation where it affects the company's ability to continue as a going concern. So in that type of situation, will compelling staff to accept those types of changes possibly be acceptable. But other than that, obviously then it will become automatically unfair. So what we're recommending is that you review contracts to see if to ensure that they allow you a degree of flexibility. Look at your variation clauses to see if that allows you to make contractual changes. But really, consultation is key with your staff, and ensuring that if you're thinking of implementing any changes, you get the buy-in from staff. So for instance, if you're going through a potential redundancy situation and you could avoid that by considering temporary pay cuts, if you consult with staff and try and get their buy-in so that they recognise by agreeing to do that, it could avoid them being redundant and the colleagues becoming redundant, then clearly that would be acceptable, because you've then got their buy-in and it's been agreed between you. But other than that, this firing and rehiring practice will be prohibited. And just going on to talk about the other changes beyond January 2027, what is coming down the line. And I sort of apologised in advance because a lot of these changes, we've yet to see the regulations surrounding it. So as and when during the course of the year we get to know more about the regulations and understand more about the nature of these changes, obviously we'll update you all, and perhaps we'll look to put on another webinar later in the year once more about these changes are known. But just going through those so you're aware of what's around the corner, there'll be increased pregnancy and maternity rights. You're probably aware of the current position in a redundancy situation where pregnant staff on maternity or coming back from a period of maternity have priority in terms of suitable alternative vacancies. This is designed to supplement that really, and the idea is that moving forward from a date to be announced next year, pregnant staff, staff on maternity leave and staff returning from a maternity leave for a certain period, which we expect to be a 6-month period, cannot be dismissed unless there are restricted grounds for doing so. It's yet to be seen what those restricted grounds are. That will be interesting, because if you think about it, you may have staff who are coming back from a period of maternity leave and nothing, and there may be gross misconduct issues, things like that, where normally you would invoke your dismissal procedure, how that will be sort of handled against these restricted grounds. So yeah, we'll wait to see what happens there, but the premise of it is to give further rights in respect of staff who are pregnant, on maternity leave, or coming back from a period of maternity leave. We've then got changes to bereavement leave from next year. Many of you will already have bereavement policies in place and allow staff to take bereavement leave in situations where a dependent passes away. Actually, the law, the statutory provision at the moment is that staff can only take unpaid bereavement leave if they lose a child. But moving forward, the intention is that all staff by legislation will be entitled to unpaid leave for 1 week, and that will be extended to include pregnancy loss under 24 weeks as well. So there'll no longer be any sort of misunderstanding about what leave a person has to take if they unfortunately suffer the loss of a child. It will be classed as bereavement leave. The next change is sexual harassment regulations. Stephen's already touched upon this in terms of the changes and the all reasonable steps. But thankfully, at some point next year, we'll have some guidance in terms of what the government say those reasonable steps should be. Stephen handily has given you some guidance on the things you should be thinking about. But when these changes come into place next year, hopefully we'll have more certainty, so then we can advise you as to the steps you do need to be taken, as they'll be sort of set down in the regulations. We've then got 0 hours contracts, changes in the way 0 hours contracts are dealt with. 0 hours contracts will still be legal for those who use them, but just be aware that at some point next year, for staff who are working regularly and consistently under 0 hours contracts over a sustained period of time, there will be an obligation placed on you as employers to offer guaranteed work. The idea behind this is that some employers abuse the label of a 0 hours contract and in effect just employ a member of staff and they work regular hours. So under these new changes, it will place an obligation on you to offer those members of staff guaranteed work. And then just finally, in terms of the changes, there's going to be a change in terms of flexible work rights. You're probably all aware that you can refuse a request for flexible work, and the refusal has to be on one of the 8 permitted grounds under employment legislation, which includes if there's an increased, if it affects customer demand or productivity, if you're not able to recruit a member of staff to accommodate the change in hours. Those types of business reasons are justifications for refusing flexible work requests. But moving forward, that will be extended further. So in addition to explaining the reason for refusal, you'll have to explain and justify why your refusal is reasonable as well. I think certainly for our clients, we always would tell them to do that anyway, but that will be set down and become law as of next year. We've then got this idea of compensation for people who work shifts and being given reasonable notice of shifts. At the moment in law, there is no expectation on employers to give reasonable notice of shifts. Moving forward from a date to be announced next year, they will have to give reasonable notice to members of staff. And again, it's this question of reasonableness. Again, that's yet to be defined by the regulations. So we'll wait to see how the government choose to define what reasonable notice is. But in when this comes into place, if you're not given reasonable notice or shifts are cancelled at short notice, then an employee can bring a claim at an employment tribunal for compensation for the inconvenience of not being given reasonable notice and shifts being cancelled at the last minute. And then finally, Adam has touched upon collective redundancies already in the changes in law. We're expecting next year as well to be a further change. In a collective redundancy situation, it's usually at this moment in time, it is triggered by looking at a particular establishment and whether 20 or more redundancies are expected at that establishment. In other words, looking at the site, looking at a particular office. That's going to be changed moving forward. So the expectation is, and again, this is not yet clear by the way of regulations, but certainly what I understand is that the number of people across the company will be looked at against the number placed at risk of redundancy, and if it reaches a certain percentage, at that point it will trigger the duty to consult. So again, for those of you who will come across the need to undertake collective redundancies, I'd imagine that new obligation, that new duty will extend that obligation even further. So just a little bit more about us, if you don't already know us. We act for businesses in defence to tribunal claims, but also dealing with day-to-day HR and employment issues. So we have a retainer service in place, our Workplace Plus service, which for a fixed cost, you would have access to a relationship manager, a solicitor in the team who can advise you on any day-to-day HR or employment issue. That could be dealing with an issue of sickness, right through with advice about grievances and disciplinaries, helping you draft letters, helping you discuss outcomes and what we'd recommend. And built into the service as well is insurance cover as well to give you peace of mind. So in the event a claim is raised against you, your costs and any compensation is covered up to £100,000 per claim, which in light of what we were just discussing about the possibility of increased compensation does give you peace of mind. We can also assist with reviews of contracts and policies and procedures to comply with the Employment Rights Act. And our details are just on these slides as well. So after the webinar today, we'll send to you a copy of the slides, and obviously our details are on there if you wish to get in contact with us to discuss any of that further. So in conclusion, there's obviously lots to consider and plan for there. What we're suggesting is that you really just focus your minds as to the changes that are going to be taking place in April and October, which Stephen and Adam focused on, and also January as well from next year. But as to the changes that I've just talked about, which have yet to be, where a date is yet to be set down, and there's got to be regulations around them, perhaps just revisit those later in the year. And as I said, we'll probably look to put on another webinar later in the year to cover off those changes. But it is time now to consider, taking proactive steps to change your contracts and policies and procedures. And certainly with our clients over the next few weeks, we'll be looking to send them out templates that they can use dealing with all these changes.